The right to a free public defender, along with the Miranda warning, has become ingrained in American civil rights and culture.
You cannot afford an attorney, one will be appointed for you.
If you can't afford a lawyer, one will be appointed to you free of charge. You can exercise these rights at any time.
You have the right to an attorney. If you cannot afford an attorney, one will be appointed for you. Why did you stop?
As part of my series on people who represented themselves at the Supreme Court, I want to feature the Florida man who won our right to have a public defender if you need one. This will be longer than my other videos, but I can drop in audio of arguments.
If you cannot have a fair trial, the states are required to do something about it.
Clips from a TV movie, newspapers, and interviews. Clarence Gideon had a difficult childhood, getting picked up by police as a runaway, followed by time in and out of prison. When accused of felony burglary in 1961, Gideon could not afford an attorney. He asked the judge to appoint someone, but in Florida that was not an absolute right, and he was forced to conduct his own defense. Later, he and the judge put on a reenactment for CBS News with the original transcript.
Your Honor, I request this court to appoint counsel to represent me in this trial.
Well, Mr. Gideon, I'm sorry, but I cannot appoint counsel to represent you in this case. Under the laws of the state of Florida, the only time the court can appoint counsel to represent a defendant is when that person is charged with a capital offense.
According to a modern article by the National Association of Criminal Defense Lawyers, the judge was not totally correct.
Our state, the judges in our state have discretion, and they can appoint counsel when exceptional circumstances.
Are there some that do?
Yes, Your Honor. In fact, there are some judges who appoint counsel in all cases.
While in prison, Gideon did research in the prison library and hand-wrote an appeal to Florida and the United States Supreme Court. He asked for a hearing on the 14th Amendment rights of due process and equal protection. He felt his trial was no different than pleading nolo contendere, and that the Supreme Court's decision should at least apply to felony cases like his. At this time, Florida and 4 other states did not guarantee court-appointed attorneys except in death penalty cases. At the founding of the United States, the court had believed that the Bill of Rights was meant for the federal government and not enforced on the states. That argument cracked in 1932 in the case Powell v. Alabama. Multiple black defendants had been given ineffective counsel and sentenced to death in one day. According to the article Ineffective Assistance of Counsel Before Powell, one attorney met the clients 30 minutes before and was senile, and another drank during the trial. The Supreme Court overturned those death sentences, but declined to expand the right to counsel beyond death penalty cases even 10 years later in Betts v. Brady. Of the 3 justices who dissented in the Betts case, 2 were still on the court 20 years later when Gideon's case came in, Black and Douglas. This was a more progressive time, and the current Chief Justice, Earl Warren, would become known for his decisions such as Brown v. Board, Loving v. Virginia, Miranda, and other cases which established essential civil rights. The Supreme Court decided to appoint Abe Fortas to represent Gideon. He was a lawyer in the government during the New Deal and World War II, and would later become a Supreme Court justice himself. At this point, the Supreme Court was known to be looking for a model case to overturn Betts v. Brady. They were looking for a case that was simply about the right to counsel with no special circumstances.
Gideon isn't black, he's not illiterate, and he certainly isn't insane, which all makes this the perfect case with which to challenge the Betts decision.
I was the youngest and the newest, and the only one who had not yet argued a case in the United States Supreme Court, and I think that's one reason why I was chosen to handle the Gideon case.
Can you remember how other states lined up in terms of support for the state of Florida?
Our office wanted to be sure that we let all the other attorneys general know about the Gideon case, and so we sent a letter out letting them know that this issue is before the court, and also inviting them to submit an amicus brief.
22 states filed their amicus briefs with Gideon and Fortas. A few others sided with Florida.
Later on, when Anthony Lewis interviewed me, he said, "Wasn't this a terrible strategy mistake?" And I said, "No, it wasn't at all. The issue before the court was so important. I just don't think when an issue this important is before the Supreme Court that you ought to be thinking in terms of strategy."
Fortas's former Yale Law School professor, Justice William Douglas, praised his argument as probably the best single legal argument in Douglas's time on the court.
And the basic difficulty with Betts against Brady is that no man, certainly no layman, can conduct a trial in his own defense so that the trial is a fair trial. In some of this court's decisions, there has been a tendency from time to time to forget the realities of what happens downstairs, of what happens with to these poor, miserable, indigent people.
At one point, he invoked Clarence Darrow, the famous lawyer from the Scopes Monkey trial, who, in his own legal cases, would be sure to hire a lawyer.
First thing that Clarence Darrow realized was that he had to have a lawyer. Here was a man who, by our folklore anyway, and I think perhaps really was our greatest criminal lawyer, he needed a lawyer. They have not encountered a single case in the state courts in which the trial has been stopped in midstream, and the court has said, there's special circumstances here, and you better have a lawyer, because it looks to me that you're not brighter than Clarence Darrow, or you're a moron.
So I'm asking you as to whether you can draw a distinction between felony cases, misdemeanor cases, traffic cases, or for that matter, civil cases, if, as you say, you would make the right coextensive with the right to counsel of your own choice.
I was speaking only of criminal cases, Your Honor. I was not speaking of civil cases. I know that there are some people, but very few, so far as I know, who argue for the right in civil cases.
You are relying on equal protection rather than the due process.
That is equal protection. So far as I'm concerned, Your Honor, I reached the result through the due process clause standing alone, and I also get comfort from the equal protection.
Toward the end of Fortas's arguments, the court took a break for lunch. That was an opportunity for Abe Fortas and Bruce Jacob to talk.
We sat at a very small table across from each other. He talked about Justice Black and how much he admired Justice Black. He talked about the case in which he represented Lyndon Johnson in Texas when Johnson was selected to the Senate.
Next up was J. Lee Rankin, a former Solicitor General who is now representing the ACLU.
If you cannot have a fair trial, the states are required to do something about it. It just isn't true that the layman knows those rules of law. And if he does happen to hear about them, he doesn't know how to express them and represent himself.
There are many cases where you've had them, and I've seen them, and advised people in that way, where very often you would say it's the best thing that a client could do is to go in and try his case himself. We see it every day in this court.
Next would be Bruce Jacob arguing for Florida.
First of all, I'm going to point out that historically there's no basis whatsoever for including the right to automatic appointment of counsel in non-capital cases in the due process clause. Secondly, I'd like to indicate to the court that the term due process, as it has been developed by this court in many cases since the Civil War, is a relative and not an absolute concept.
From the time I opened my mouth until the hour was over, all I did was answer questions.
That there's 65% of all of your prisoners were not represented by counsel, 65%. And you had 8,000 prisoners, but therefore 5,200 prisoners had not been represented by counsel in the trial court. And then I noticed that all the time, following Betts and Brady, there's only been one decision in your state courts finding special circumstances. Mr. Jacob, I suppose out of those 5,200 prisoners who were not represented by counsel, the vast majority of them are not only poor but are illiterate. Would that be a fair observation?
Your Honor, I don't know.
Well, what's your observation?
My observation is that, in all honesty, my observation is that there are some. But I have no idea how many. In capital cases, Well, capital cases are a creature all of themselves. They are unlike any other case because everybody is fearful of being put to death by electrocution or some other means.
I suppose most people are fearful about being put in jail in the penitentiary, too.
They're fearful of that, too, but it's nothing like being put to death, Your Honor. And
I felt my job was to do my best to teach the court or let them know what the issues were and the history of the right to counsel and what was being done in every state in the union.
We cannot have a fixed rule requiring appointment of counsel in these cases and not in those cases. We cannot draw an inflexible dividing line anywhere.
Said, and that's where it's writing that they must furnish counsel in all capital cases, didn't they?
In Betts versus Brady, no distinction was made between capital and non-capital cases, Your Honor. I realize that since that case, legal writers and judges have cited Betts versus Brady for the proposition that in one place is there the word capital as opposed to non-capital. Powell versus Alabama was decided on the circumstances in that case, Your Honor. There, the court held that in a capital case where a man can show that he is illiterate, ignorant, or incapable of handling his own defense, he should have counsel. The fact that a man can stand trial by himself does show that at least this court isn't too concerned about a man not being able to receive a fair trial. I think there are circumstances where he can receive a fair trial.
And the question of retroactivity, should the case be retroactive? So there are many issues beside the main issue in the case.
We urge that if the court does decide to reverse this case, we implore the court to find some way to not make the rule retroactive, because the state of Florida and the other states which have followed the Betts versus Brady doctrine have done so in good faith. So if this court were to reverse the case and impose an inflexible rule in all criminal cases, as I pointed out in our brief, approximately 5,200 prisoners would be at least eligible to be set free. And I'd like to point out that Florida, until the last year or two, has not required that the transcripts to be taken at arraignment. In many cases, it would be difficult to get information to show that a man had waived or had not waived his right to counsel. If we require that counsel be appointed in all cases as a necessary requisite of equal protection, states would also be required to appoint counsel in civil cases. The court would have to see to it that a man is given investigators, that he's given psychiatrists and expert witnesses if he wants them, because those things are available to the man who has money. This court would have to see to it that every man is equally entitled to bail. The state would have to give him money for bail if he couldn't afford it. This court would have to require that all states provide for a lawyer on appeal or in post-conviction proceedings or in appeals from post-conviction proceedings. In effect, the court would be requiring that the states follow a program of socialism or requiring that the states adopt a welfare program.
The court also heard from George Mentz, representing Alabama.
We say that a state should not be burdened with the expense of appointing an attorney who in good conscience could recommend only to his client that he enter a plea of guilty.
Can't you conceive of the possibility that many of these pleas of guilty are entered by people who, if advised by counsel, would have pleaded not guilty and might well have been acquitted?
Well, yes, sir. I admit that certain cases might turn that way.
The court unanimously sided with Clarence Gideon.
Was listening for the decision on the radio. When it came on, most of the prison population heard it. You could hear them holler for 10 miles, I suppose, from there.
Out of the 8,000 people held in Florida prisons, 3,000 would get a new trial. One newspaper reported on 2 prisoners who received harsher sentences in their new trial. After some delays, Clarence Gideon returned to the same court that had convicted him. Rejecting offers from the ACLU, Gideon asked the judge to appoint a public defender.
I knew Clarence before he ever got in trouble, but I didn't know that I was going to be in the case until Judge McCrary found me in the hall and said he'd appointed me.
He was acquitted.
Was the most important thing in this whole case. It showed the difference, definitely, between not having an attorney I'm dealing with an attorney.
Gideon said that more than anything, he wished he could have a McDonald's hamburger. According to the newspaper, after release, Gideon worked at gas stations and only got in trouble with the law one more time. According to Anthony Lewis, who had written a book about the case, Clarence Gideon was arrested and brought before a judge. Gideon presented the book, and the next day he was released. Clarence Gideon died in 1972. His letter is reportedly at the Rubenstein Gallery in the National Archives. A TV movie was made about Gideon's life in 1980, starring Henry Fonda. It's free to watch on YouTube. In 1984, the ACLU commemorated Gideon with a gravestone and a small ceremony. Locals were somewhat critical of the ACLU and the efforts to memorialize him. This was the first time I saw that people were skeptical that Gideon had written the letter himself. In 2003, a commemorative marker was placed at the Bay County Courthouse in Florida. Fred Turner, Gideon's lawyer, took part in the dedication and met two of Gideon's children. After arguments had completed at court, Abe Fortas and Bruce Jacob had a brief conversation.
He came up to both of us in the hall and said, I felt I'd done a terrible job. But he said, you have a wonderful way before the court, which meant a lot.
Gideon changed your life in many ways. Since 1963, the year you decided to enter teaching, you have represented thousands of America's prison inmates.
I've started legal programs for indigent defendants and for prison inmates in several states at several law schools, at Emory in Georgia, Harvard Law School in Massachusetts, Ohio State in Ohio, and of course at Stetson here in Florida.
After becoming a professor and later a dean at a law school, Bruce Jacob has taken his case to be a teachable moment, and in the past 20-odd years has become something of a historian of the case.
My personal belief was that every defendant in a felony case should have an attorney, and I was happy with that result.
In 2000, Bruce Jacob met Fred Turner, the former attorney of Clarence Gideon. From conversations they had before his death in 2003, Bruce Jacob learned and later published that Gideon had been coached by his cellmate, a former municipal judge. This is such a strange case to talk about because it sounds like this David and Goliath case, and then there's this redemption arc for the one guy who's still alive today, and then it has such a specific interest in details of Gideon's trial.
In the pre-sentence investigation report, which we handed out, Gideon admitted that he had been in the Bay Harbor pool room and had taken the items he was charged with taking. He admitted he was guilty of petty larceny, but said that the door had been open when he entered. Therefore, the key eyewitness who testified against Gideon was impeached on the basis of a lie, but as it turned out, it was not a lie, and he should not have been impeached.
But he's actually done a lot more than I can cover here, including bringing a prisoner's petition to the Supreme Court in Kaufman v. United States, and winning an award from the National Association of Criminal Defense Lawyers for his pro bono work. And with that, that's just about everything that I could find online about this case. If you want to hear more episodes about people representing themselves at the Supreme Court, please like and subscribe. United States Supreme Court rules and practices have changed since these cases. This was a podcast episode, not legal advice.